Now we are going to give the floor. We're going to give the floor to Dr. Daniela Salazar Marín. She's going to present us the case. The judiciary is a tool to silence freedom of expression online in Ecuador. Dr. Salazar is a very distinguished scholar who, from Ecuador, who is the deputy president of the University of San Francisco, who has had a very distinguished teaching career and who has participated actively in this research, giving to the whole project not only credibility, but a lot of insight into how this government aims to repress freedom of expression in Ecuador. Please, Dr. Salazar.
Good morning, everybody. First of all, please excuse my English. It's not what it used to be, but I'm going to try my best. Thank you very much to the Inter-American Democracy Institute, especially to James for these invitations, for putting it all together, and for the Inter-American Bar Association, and for all of you who are here. If you're here, it's because you're interested in the human rights situation in Ecuador, and that is already a lot to say. It's not a country that has drawn too much international attention. And sometimes it feels very hopeless to be in Ecuador, where the judiciary is not going to protect you from any human rights violation. And if I know something, is that Correa really cares about his international image. And so if international actors can start moving to put a little pressure on Correa, that might actually have a change in the situation of human rights in Ecuador. So thank you very much for being here. Writing a book about basically corruption between Correa's government, Correa's brother and the government. There's another very famous case of El Universo, where Emilio Palacio wrote an opinion piece in this diary, El Universo, and they were convicted to pay $40 million to damages to Correa's image also for this case. And in this context, Correa approved a law, they passed a law in the government in 2013, a media law that has basically caused a lot of censorship. There is an executive government, a superintendency, that controls the media and fines them weekly for anything they say against the government. And this has caused that, in order to survive, media have restored to self-censorship. Yeah. And so anything you see on the media, anything that's really happening, you don't really see on the media. And that's why I wanted to tell you this, because social media, whatever happens on the internet, has become a very important place to denounce human rights violations. If there is a protest, you cannot see that on the media. If there is a case that has not yet been decided by the judges, you will not read that on the media. Where can you find that information, and where is most of the public debate taking place in Ecuador? On social media, because they have not been able to control social media through this law. So that's why I picked this case on freedom of expression on the internet, because the government has realized that, and now it's eager to control the internet as well. Also, still on context, in 2011, the government received a popular mandate to carry out an extensive judicial reform. Yes, the judicial power was before very questioned. There was a lot of corruption in the judicial power, and so Correa received this very broad mandate to reform justice. And what they did is that they appointed and removed hundreds of judges through very questionable mechanisms. And that is how today Correa controls the judicial power. It is in this context that I am going to present you with this case. It's not one of the most renowned internationally cases on human rights violations in Ecuador. When I was asked by James to identify a case where the judiciary has played a role in the human rights violation in Ecuador, I was trying to find a case where nothing would have happened if the judiciary had not acted. So there was no protest, no military, no police involvement, nothing would have happened. The human rights violations started the day that the judiciary started acting, and that is what happened in this case. The facts, very briefly, this happened last year, around the end of July. His name is Sebastián Ceballos. He's a very young, not even very famous, but like a political leader in Cuenca, a very beautiful city in the south of Ecuador. And he used information, public information, just to find out how many people who were family members of a very high minister, the Ministry of Labor, how many of his relatives were working for his government, which is prohibited by the law in Ecuador. And so he identified more than 20 relatives of this ministry who were in different positions throughout the government. And he put that in his social media, his Twitter account. There was a series of Twitters just announcing, well, there is this person who has this relationship to the ministry and is working here. And he just put together a lot of information on that. And that is all he did. One of his tweets, once against a niece of this ministry. And it literally just says this: Paula Rodas, that was her name, Paula Rodas, niece of Carlos Marx, that is the name of the ministry, Carlos Marx. Ministry of Labor too, which is a little ironic, but okay, I'll go back to my case. Paula Rodas, the niece of Carlos Marx Carrastro, works for this institution. And then there was an opinion. He said, he's literally the Ministry of Labor of his family. Just to put it like a little ironically, that is all he said in his tweet. So Paula Rodas felt offended that someone would question why she was there. She had been working for the government for like 6 years before she actually had a contest on merits. But she thought no one should question that she was there on her own merits. And instead of maybe just tweeting also in her account that this is not true, or why she's there or what her merits are, maybe even a press release or something like that would have been sufficient if there was any misinterpretation about why she was working for the government. But she prefers to use criminal law, as many people are doing in Ecuador. The tweet had two facts. She's the niece, she's working for the government, and an opinion. There is no hate speech, no incitement to violence, nothing. But you can still use criminal law in Ecuador against these cases. And so he was criminally prosecuted for allegedly attempting to her reputations. When I moved back to Ecuador in 2009 and I started studying some of the judicial decisions, they were very poorly analyzed compared to anything I had been studying, for example, here in the United States, when I had the chance to do my LLM here. And I thought maybe the lawyers are at fault. And I thought maybe if we as lawyers put out good arguments, then the courts will have to incorporate those arguments and at least respond to them, and then the level would raise. And this case shows that is not enough. In this case, the prosecution showed nothing. There was just a tweet. The lawyer for Paula Rodas based his whole argument on her being a woman and how a woman should never be discredited for that because she's a mother and because she comes from a very honorable family. That was his whole argument. And on the other side, the defense put up a brilliant defense. They really used all international human rights standards on freedom of expression to state why this is first public information There's just nothing wrong. He wasn't even a whistleblower. It's just public information available to anybody. He was just doing his duty as a citizen to control the government and to criticize or question, what's happening with public funds. And it was protected speech. The defense was brilliant explaining why this is protected speech, political speech, under international human rights standards. But the judges are not up to these arguments at all. I can't even analyze the legal reasoning of the judge because there is none. There is zero there. It's completely lacking any reasoning. The judge didn't do a test explaining, there are two rights in conflict, freedom of expression, her reputation, nothing at all. The judge has such a limited comprehension of the law that, faced with this argument on protected speech, the judge says this was not speech, literally speech, because it's a tweet. And I guess for the judge, you can only give a speech if you're, standing with a microphone in front of 1,000 persons and giving a political speech. Literally, that's a speech, but anything else was not a speech for the judge. His comprehension on the use of internet and how the internet works, also very limited. In fact, when he takes the evidence against Sebastián Ceballos, the judge does not only convict him for this tweet, but also for 11 retweets. So you can be criminally liable for pressing a retweet button, which does it with opinions from other people, which does, you didn't do anything to say you agree with it or anything like that. And so that's how Sebastián was convicted to 15 days of jail time, which doesn't sound like a lot compared to some of the cases you're going to hear today, where people have been convicted to 4 or 6 years of jail time. But we're talking about someone who is, he just said something, he wrote something on a tweet, and it's absolutely disproportionate that he has to go to jail for that. Of course, this judicial decision was confirmed on appeal, and there was nothing to do there. And the reason why I chose this case is because it has had a devastating chilling effect on everyone else. I can tell you myself. And to maybe answer Douglas Cassell's, one of his caveats, I was not a lawyer on the case. I don't know Sebastián Ceballos. I've never met him. But this impacted me. I feel like if I had had that information on the ministry, I may have tweeted it too. Those things worry me too. I could have written the same exact tweet, and I don't want to go 15 days to jail. And so I think 5 times before I say anything in Ecuador or before I tweet anything in Ecuador. And I know that's how a lot of people feel because of the chilling effect of having to maybe face jail for something that you are supposed to do or you're supposed to say anyways. And this is not an isolated case. There are many cases like this where people who are in power have used criminal law to silence their critics. In fact, last week, or maybe 2 weeks ago, the vice mayor of Quito, also he gave an interview in the radio, and he's also been convicted to jail because he offended President Correa. So he's appealing right now, but he will probably go to jail, even if it's 15 days, 30 days. This is not an isolated case. It's happening all the time in Ecuador. And what it shows to me is that no matter how small or how big the case is, if you are facing government interests in a judicial case in Ecuador, you have no hope. No judge would ever decide a case against a government interest in Ecuador. I also wanted to bring up this case here because there is something you can do here in the States to protect the internet and freedom of speech in internet. Correa cannot use the media law to sanction free opinions on social media. The law expressly excludes that from its mandate. However, Correa has figured out that the DMCA, a law here in the United States, allows any person to take down content from social media, from Twitter, from YouTube, just by claiming that that content is violating intellectual property rights. And Correa is doing that all the time. People who use, for example, a picture of Correa taken from his official account, or Correa in a public speech, and anybody using that picture to post any information that's maybe uncomfortable for the government. Correa is saying those are my intellectual property rights because that picture is mine. And with that, he takes down content from the internet every week on very on questionable grounds. Now, let me tell you how this case finished. After he was convicted and in appeal that was confirmed, he was pardoned. He was pardoned by, he was pardoned by Paula Rodas. Now, this is not isolated either. Correa did the same with these cases I told you at the beginning, and in the case of El Universo, and the case in El Gran Hermano. Correa waited till those convictions were set, and then he pardoned the victims. And that tells you two things. First, that leaves you with no international human rights mechanism of relief. Yeah, you may have the relief that you're not going to jail, or in the case of El Gran Hermano, you don't have to pay $40 million. That sounds great. But you could never bring your case to the Inter-American Commission or the Human Rights Committee at the United Nations because your case was solved internally. And that's worrisome. But even more worrisome is that, and I find this very dangerous, the message that it sends. The message that this sends is that the only source of justice in Ecuador is the executive power or the president himself. That's the source of justice. You cannot get justice from the judges. The justice comes from the good heart of the president. And that is how people feel right now in Ecuador, thanks to these cases. So I know I only have 15 minutes, and I don't want to take more than that. My clock says I did 15 minutes already, but I can respond to any questions now or later, if you may. Later? Later, he says. Okay. Thank you very much.
The question is here.
Okay, now?
I'm curious, you said that because of the pardoning, you cannot submit the case to an international human rights mechanism. I don't know that I can fully agree with you on that. Because at the end of the day, you're not going to appeal your conviction. Maybe Doug has some further comments on that.
I think technically you're right, but in practice, it effectively bars international action because it reduces the level of the case so that, for example, in the European system, you know, the new language about unless there's substantial injury or something, it wouldn't pass that hurdle in the European system. And in the inter-American system, the resources are so limited that they have to really prioritize the most serious cases, and this drops it below the bar. So technically you're right, but as a practical matter, I think it does effectively end any real possibility of international review.
Yes, and to accept it, and when you accept it, then you also commit to not bringing this, any farther in injustice. And then, as Douglas, Professor Cassell just said, if the case has been solved, the Inter-American Commission will probably not take it, or the state would have a really good defense saying this has been solved already. There is nothing else that can be said internationally. But political pressure measures are still there, and so that's why I wanted to use this case here.
The president didn't pardon who he had sued, and it was the Banco de Pichincha case, where he sued the bank. Then he got a judgment given him, basically earning him $600,000, which he then used to buy an apartment in Belgium. Of course, he didn't pardon them. He took the money and he used it, which, by the way, takes the whole thing to a very different terrain, which is corruption. Because when a sitting president goes around suing for libel, for opinions, that is called corruption. You cannot do that in a democracy. That's what he does.
Interesting, because what you just said is something you could never say in Ecuador right now. That is exactly what this is exactly what the vice mayor said a couple of weeks ago in his radio interview. What we're saying here, in his interview, he claimed that Correa was using the judicial power to get money and send that money to Belgium. That's all he said. He actually didn't mention Correa. He just said it generally. Justice is being used to get money and send it to Belgium. And he's been convicted to jail already. So,
Well, this is being live streamed, so I don't know yet about it.
good luck. I'll give you my card. I'm a lawyer. I can try my best in Ecuador.
Thank you so
Thank
much.
you.
Let's give her a round of applause.